we'll talk about the Arbitration and Conciliation Act 1996, right? So this is the BAR Act, which means that it's a simplified act. The original act is pretty much longer, and it has got almost a lot of things like case studies and all. This is just a gist of the Arbitration Conciliation Act, right? So this is just a concise form of this particular act, and that is why it is called a BAR Act or something, right? So part one is the arbitration. So we'll look into the definition and other related stuffs regarding arbitration. And chapter two is arbitration agreement. So this is something between parties in which they agree to do arbitration in case of any violation or mishaps, you can call, not a violation, right? And chapter three is composition of arbitrational tribunal. Like tribunal is the the arbitrator, the group of people or individual or sole arbitrator to deal the case, like arbitration issues or dispute issues. And chapter four is the jurisdiction of arbitration tribunal, like where or which place you can have the arbitration, something like that, right? So that's what basically the jurisdiction of arbitration tribunals. And the conduct of arbitral proceedings, that's the actual process of arbitration. And then chapter six is making of arbitration award, which means the final outcome, the verdict, the arbitrational verdict, we call arbitral award. And termination of proceedings. Sometimes it can be terminated by giving an award or interim itself, like if the party agrees to amicably settle for the losses of one another, like something like that. So in that case, it can be terminated or something like that. Or sometimes if the case cannot be solved, right? So it's too complex or it does not have any consensus met, then also like arbitrational tribunal requests this to be sorted out by other means, like they stop the arbitrational but they can go for other later stuffs, something. And chapter 7 is recourse against arbitration award. So if you want to appeal or want to refute the award given, you can even do that. This is like a court appeal, no? So how do you appeals against the verdict or something like that? And then finality and the enforcement of arbitral award. So we'll talk about that in chapter 8. And chapter 9, we talk about appeals and appeal orders and so on. And chapter 10 is miscellaneous thing like deposits and arbitration agreement not to be discharged by death of party of thereto, something like that. Like something which we cannot deal with, regular sense. Like in case of insolvency, like what happens if that guy is bankrupt? We cannot ask him to pay money or the fine amount or something like that, right? So in that case, what can be done? And other things like jurisdiction limitations and so on. So we'll take a look at that in much detail. And part two, these are the other arbitrational proceedings, or in fact, this is the international arbitration or the foreign awards. Like there are two things like New York Convention awards and Geneva Convention awards. So like these are two important, uh, formulation of International Arbitration Act or something like that, right? So in fact, we'll talk about this after CAT 2, right? So this lecture will be focusing primarily on arbitration and conciliation, the generic perspective of Arbitration and Conciliation Act 1996. Then part three is about conciliation. As I told you, this is different from arbitration. Conciliations are like amicable settlement before getting into arbitration or something like that, right? So that's conciliation. And people who does the role of conciliation are called conciliators, like the third party. It could be a single person or it could be two or three person. Like it's not like an arbitration tribunal, something like that, right? And all this thing will be doing in part number 3. So let's get into what is arbitration tribunal. Part 4 will talk about supplementary things like supplementary provisions like power of high court to make verdict or rules or something like that, or rulings they generally say. Then power to make rules, reappeals and savings and so on. Like there are some 7 schedules. We'll take a look at that in much detail part. So without further ado, we'll get into the arbitration. So the Arbitration and Conciliation Act 1996 is Act number 26 of 1996. So what does that mean is An act to consolidate and amend the law related to domestic arbitration, international commercial arbitration, and enforcement of foreign arbitration tribunal, right? So, as also to define law relating to conciliation and for matters concerning therewith or incidental thereto. So, which means that so it is applicable to domestic arbitration, international commercial arbitration, and also foreign awards within the matter of dispute, like industrial dispute or something like that. So, first, United Nations Commission on International Trade Law, UNICITRAL, it's called UNICITRAL. They initially formulated this, model law called International Commercial Arbitration in 1985. And then UNICITRAL also had adopted conciliation rules in 1980. So, these two are the primary document or primary acts based on which the Arbitration and Conciliation Act 1996 were made. Right. That's what's given here. And whenever you talk about act, it should be like the you should see the coverage. It extends to the whole of India. It also includes Jammu and Kashmir, provided it should have some international commercial arbitration and something like international commercial conciliation, something like that, right? And then what is arbitration? Arbitration means any any arbitration process, whether or not administered by permanent arbitrational institution. So which means that this is just alternate dispute mechanism, dispute resolution mechanism, in which you would have stated in the clause of your contract, say any violation can be dealt with conciliation first, then the arbitration or something. And arbitration award is the general interim award, which is the verdict. And arbitrational tribunal means sole arbitrator or panel of arbitrators. So here the panel can be even 5, 10, or something. So it doesn't matter. Unlike conciliation, conciliation can have 3 people, a maximum more than 3 people. But arbitration panel can have multiple people based on the severity of the case, right? Something like that, or the reasons, right? So for a simple problem, they can go with the sole arbitrator, right? Something not don't have to specifically mention or require a lot of arbitrators. If the if the particular case needs some experts, then they can find out the experts in the field. Say for example, if a building collapse, so they can invite some renowned structural engineer or even forensic structural engineer to investigate the matter. So in that case, they can add him or her as the arbitrational tribunal, one of the member in the arbitration tribunal for expert opinion. Because sometimes most of the arbitrators are from legal side, so they may not understand the technicality or the technical part of the dispute or something like that, right? So in that case, they can have person who have got expertise or something. That's why arbitration tribunal has got different panels, like, right. So it's a civil court of original jurisdiction in a district, or it could include high court in exercise of its original civil jurisdiction. So this is how the jurisdiction means, which means the court means here. Okay. Then international commercial arbitration. So which means that anything related to dispute arising out of contractual nature, not only from parties within our country, but also one party may be from another country. Say it could be a national of or habitual resident of other country other than India, or it could be a corporate agency located in other than India, or it could be an MNC whose work and control are majorly in the outside of our country, or a government of foreign country. So all those things comes under international commercial arbitration. Even though we just quote for national product or project, but then like if the company was from other country, so that's something like it becomes an international commercial arbitration. One example is like the IPL, the Indian Premier League. So you can probably see the different teams, and then they have some players from abroad, foreign players. So there's something called rules, no? Like they cannot have more than some numbers of foreign players in a team or something like that. right? So something like an international arbitration means like it is, even though it's an Indian cricket match, Indian Premier League, so they get players from abroad, so that they have some rules and regulations and so on, right? So that case is international commercial arbitration, and they don't even appeal if there's anything happen or anything they wanted to appeal or to get justice. The foreign players only go to ICC, not BCCI. Maybe they appeal BCCI, then they can go for ICC, right? Something like that, no? So that's kind of an international commercial arbitration. For any other problems like a ban against a player or a ban on a player, Indian player can be taken by BCCI. So as simple as that. Right. So in that case, they can go for international commercial arbitration, something like that. All these things are legally, binding. So people have to really look into the corresponding person, like something like that. And all these things you can read. It's a very big document. I'm just highlighted few important things. Okay. And generally commercial national commercial arbitrations or domestic award, unless it is an international commercial arbitration, right? So in that case it will be an international award, right? And all these things like the extent of jurisdiction, administrative assistance, like this is what I told you. Suppose a arbitration tribunal requires people who have got competency and also expertise, then they can arrange for administrative assistance by a suitable institution or a person. Say, for example, some product they manufacture were not high quality stuff. In that case, the arbitrators or maybe from legal side, so they can get some help from the quality control engineers or sometimes the national laboratories. Those can be put under institution, right? So for checking whether the product is really worth or not within the standards or something like that, right? So one example is the Maggie. The Nestle's Maggie was considered to be unsafe for consuming, but then it was banned for quite a few months time, and then it now in market. They cleared the the dispute, and then finally they say that they'll change the components to make it healthier or something like that, right? So that is something like an administrative assistance. They checked that with the help of some laboratories, Indian laboratories or something like that, right? Then arbitration agreement in the clause or in the contract nature, the arbitration agreement happens like the agreement between parties to submit to arbitration. If one were reluctant to go for arbitration, they may not, actually have arbitrational tribunal, right? So it'll be, probably unsettling issues like, but generally, in a contract clause itself, they'll mention any violations. Both the parties should go conciliation or arbitration, or sometimes both, something like that, right? So that's one important thing. Then other things are not pretty much important, right? So yeah, next is composition of arbitral tribunal. This is a very important thing. Generally, in an arbitration, whenever an arbitration act is asked, like the key portion is the arbitral tribunal, right? So you talk about the composition of it, and then their powers and responsibility. So chapter 3, from this point onwards, is be very important concepts like the number of arbitrators, like how many arbitrators can be appointed. So it is pretty much choice of the both the parties, like they can free to choose any number of arbitrators, but generally they provide it in even numbers like 2, 4, 6, because what happen is, say finally there is something called majority. Say, for example, if you have an odd number, that one person verdict might be, detrimental to the arbitral award, right? Say, for example, if you have three people, and if two agrees, and if one does not agree, and then it becomes something like one does not agree, and majority is two, something like that. But if it is in case of two, if one agrees and one does not agree, then they can rethink of like there's something detrimental. So if both does not agree, or both agrees, or both giving the verdict against the respondent, then we can have a clear cut solution. That's why it will be generally in even numbers like 2, 4, 6, 8, and something like that, right? And other than that, like arbitral tribunal shall consist of sole arbitrator also, like single person whose expertise. Say for example, a person who does the job for 40 years and who has got legal knowledge also, and if he has taken place in arbitration tribunal, he himself is more than sufficient, right? So in that case, they'll go with sole arbitrator. Or sometimes if you don't find any person or that expertise, say for example, one person is probably considered to be the godfather of a particular technology, like if it is a laser, some person from United States might have developed a lot of laser technology, so you can even bring him for arbitration, right? Say that will add weightage to the case, but it will be always riskier, and it will be always expensive to bring experts, sometimes. But if the company or the parties request, then they can go for any person from any nationality and something like an arbitrator, but it should be agreed by the parties. I mean, and something like the other aspects are something like the court proceedings. You can take a look at that in much detail. And power of central government to amend fourth schedule, and other related stuff like grounds for challenge. Like when the person is approached in connection with this possible appointment as an arbitrator, he can shall disclose in writing any circumstances. Right. So when arbitrator was not properly assigned, so they can go for challenging procedures. And failure, this is very important. Failure or impossibility to act, like this is very important. The arbitrator shall be terminated, right? So, and he has to be substituted by another arbitrator, right? Sometimes the arbitrator were not initially they might have thought like he might be fitting to the case to investigate the matter, but finally they think that like he may not have that competency. The arbitrator should have a competency to investigate the matter both in terms of legal and technical. But if you don't possess anything, then you can ask for change of arbitrator. It does not matter. It is not like a civil court where you can change a judge. So civil court you cannot have the provision to change that. But in arbitration, you can request the arbitral tribunals to change one of the arbiter, or if there's only one arbiter, they can ask the parties to agree to change something like that. And competence of arbitration tribunal. This is very important. So jurisdiction of arbitration tribunals, like the arbitration tribunal may rule on its own jurisdiction, including rulings on any objections with respect to existence or validity of the arbitral agreement. So it's all about the evidence and the agreement and the contract clause. So it's not like civil court of proceedings where a judge can investigate, interrogate person from other nature related to the case. Something like, they only look into this based on the documentation and something related evidences. Right. And all those things like interim measures ordered by arbitration tribunal. Interim measures is like at that point after verification of the documents, they just give an award. But before it is enforced in accordance with the final arbitration tribunal, uh, if they find that like 90 percentage is one-sided, the case is one-sided, the tribunal can request the other party like this case is against you, but you can either settle in between the final verdict, or if you want to continue further, or you want to appeal after the verdict is given, something like that, right? That's called interim measure. And something that it's pretty much important is the arbitral proceedings, like how they conduct the case and something like that. So arbiter should be unbiased, and he should give equal treatment of the parties. He should listen to both the parties, with the same manner, and with should be given the same time, right? So not only the respondent, but also not only the person who appealed, I mean, who applied for arbitration, or the person who called complainant, but also the respondent, like the other party. right? So equally, there should be an equal. And place of arbitration can be any place, like any place mutually agreed by both the parties. Sometimes one party might be from north part of our country, and the contractor may be from southern side, so they can have a mutual place like where they can meet, right, something like that. So if one agrees to provide it in place where the other cannot come, then that's not a, you know pretty much a good practice, or sometimes it will be refuted generally, because unnecessary delay or duration can be a detrimental to both of them, not only the complainant but also the respondent. So they'll generally, before that itself, they'll try to do it in conciliation, but once they fail to get some consensus from the conciliation, only they go for arbitration, and then they can mutually agree the place, something like that. And language, like they're free to agree upon the languages, like say for example, contract between and Gujarat merchant and from Karnataka construction company. So there's a language difference, but they can mutually agree to do it in English or in Hindi, whichever is common to both of them, right? Something like that, right? Language is not a pretty much problem, right? And statement of claims and defense, like within the period of time, the parties have to submit the documents for the complainant. They submit the claim, so and so have done this thing and which is not quality, and some claims. And respondent also have to submit the defense document, like they say it is because not because of them, it could be unexpected or something like that, or it is, they say it's quality only, not uh, as refuting against the claim of the complainant or something like that, right? So that's something called statements of claim and defense. And hearing and written procedure, just hearing happens like a normal court proceedings. They will be summoned to appear in court that particular day. The representative or the respondent and the representative of the complainant or the complainant themselves appear, and then they'll sort out that issue. And this is not more like a civil case or criminal case, it will be just like a formal legal proceedings. And unless otherwise agreed by the parties, without showing insufficient cause, the claimant fails to communicate a statement of claim, or if the respondent fails to communicate his statement of defense, in that case, one will be taken as the default, which means that if the complainant does not have a good claim to say that the respondent is wrong, then it will be against the complainant. The case will turn against the complainant. Or if the respondent does not have a valid document to for defense, in that case it will be against the respondent, and then the claimant wins, and vice versa. So it's all about how you submit the document. So this is very important. And as I told you in the beginning stage, experts can, it's also appointed. Like if if they need some technically sound reasoning and knowledge, they can appoint a person who has got that competencies to evaluate the matter. So that's the expert appointment by arbitration tribunal. Then court assistance in taking evidence. Sometimes this can be transferred to court also, where like the normal civil proceedings, the court will take the verdict, or that will deal the matter with the evaluation of the evidences and all. And then chapter 6 is the making of arbitration award and termination of proceedings. This is very important. The decision making by the panel of arbitration, right? With one or more than one arbitrator, the shall be made in majority of its all members. As I told you earlier, like one arbitrator, it's just the verdict. But if it is three arbitrator, then if two agrees and one does not agrees, it will create confusion, and generally it will be two members, right? Say in a even number thing, like 4 out of 4, if 3 agrees, it becomes some major stuff, right? And one disagree also, they can finally give a verdict based on the majority. That's what is given here. And time limit, this is very important. Kindly make a note of it. So the arbitrator award uh, despite any complexity of the case, they should give a verdict or award within 12 months of the date of arbitration tribunals. Like, say, if the arbitration tribunal is set up today, say 10 Feb, they should get by the next year, Feb 9, something like that, within 12 months, like from the date of today, right? Something like that. It's very important because they cannot delay this. This is not a civil case where it can runs for 20 years or something. That's why people go for arbitration for industrial disputes rather than civil proceedings, right? So in civil proceedings, that can even go many years, so without conclusion, right? So that's the advantage of arbitration. Right, something like they can go for fast track procedure also. Like if they wanted before 12 months, they can appeal in court, but they have to pay some fee to have the fast track procedure, and it'd be minimum of 6 months, but not less than that because they need some time to evaluate the evidences and all, right? So 6 months, less than that, depending upon the nature of the problem. And sometimes they'll ask to settle amicably between the proceedings itself, so in that case they can go for termination, right? So that's what we call settlement. Arbitrational proceedings encourage settlements, like why they want to go by this arbitrational procedure. They can find one if 90% mistake is on one side, so they just request it's your mistake. You can rectify that by compensating that, right? So that will be benefitable to both because if a 90% mistake is there, then the award will be against them only. So even then they have rights to appeal against, but then it will be time consuming. So if it is a complainant mistake, then it's detrimental to the to him because he loses the contractor's job, contractor's help, as well as the projects gets hanging, right? So in that case they can settle and then they rescind the work or something like that. If it is against contractor and the contractor pays money because he needs the project to be delivered so that he does not becomes blacklisted in future for violating the contract or something like that. So generally it will be settled in between. And these are the form and contents of arbitration award. Like it will be written and signed by all the members of the arbitration tribunal. So that's the final verdict on the. I tried online for finding out the actual documents of arbitration and arbitration awards, but I think all these things are confidential, and also generally they don't reveal that outside because it's between two parties, right? So judge signature, and then the arbitration award will be generally one-sided or one against one party, so they don't disclose that. Or sometimes settlement, they both settled, and then finally they'll have a statement that all well, that ends well, so everything cleared or something like that, happy ending, something like that, right? So they don't disclose that. And then cost of payments, like the fees, the legal fees and something like that. So this is not very important, but this gets varied. And this is very important: termination of proceedings. Like what are the situations where the arbitrational proceedings itself is terminated. One thing we talk about settlement, it's not termination of proceedings, but it is just like withdrawal of that, or you can even call that, that's one some sort of termination of proceedings. But what are the other actual termination of proceedings is that the arbitration tribunal shall issue an order for terminating of the arbitration proceedings. Like the arbitration tribunal orders termination proceedings where the claimant withdraws his claim. The complainant withdraws the claim. Like for example, one gives a case and finally he withdraws. Okay, that might be because they settled it, out of the court, or they understand each other and finally they rectify, or they speak with the stakeholders and then they get a consensus or something like that. So in that case, the claimant withdraws its claim, or the claimant feels that it is unnecessary to sue the contractor or the respondent. He can withdraw the case, something like that. And then the parties, both the parties agrees on the termination of the proceedings. Like in that case, like both they don't want to prolong it, like it becomes a settlement or something like that. They wanted to withdraw the case or something like that. And then the arbitration tribunal finds the continuation of the proceedings has no reason for any other reason becomes unnecessary and impossible. Like for example, they don't meet a clear consensus or meeting. So in that case, they can go for a termination of the proceedings. Like if this case, when they investigate, they find maybe mistake from both ends, so whom they can give verdict against, or if both of them are not, it's only the misunderstanding about between them. In that case, it will be inconclusive, right? So in that case, they can request the parties to amicably settle among themselves, and then they can terminate the proceedings. So these are very important things. So termination of arbitrational proceedings. And correction and interpretation of award. Sometimes a wrong verdict were given, they can have appeal to correct it or something like that. So all these things are given here. And recourse against arbitral award, like application for setting aside arbitration award. Recourse to a court. Say for example, if one person is not happy with the one party is not happy with the arbitration award, then he can recourse redirect to a court against an arbitration award made by the applicants, something like that, right? And these are the some of the other things, like say the arbitrator are also human, right? So they might make mistakes, or they might overlook into an evidence, or there could be substantial evidence that could make a award, but that was for a false or a forged document. Then they can go for some serious civil proceedings or something, right? But generally all these things all depending upon the two parties, right? So how they generally do. And finality of arbitral award. So whatever the arbitral award will be final and binding, right? So there's no other thing. And enforcement is they should follow that, and it will be generally accordance with Code of Civil Procedures 1908, right? So in the same manner, what a court does, the award is also will be the same. And then appealable orders. If one party feels like refusing to refer arbitration under Section 8, or refusing to grant any measure under Section 9, all these things they can appeal for. Also appeal to court from an order of the arbitration tribunal, something like the arbitration tribunal orders the matter to be settled in court only, then it can be appealed to court. And then they look into deposits, like once one party is proven guilty, then they have to pay the amount of the loss or something like a deposit, right? um, so all those things like given here, right? Something like when death of a party, like they have a legal heir to take care of that and something like that. And in case of insolvency is bankruptcy, like when it is provided by a term in a contract to which an insolvent is a party, that any dispute arising thereout or in connection therewith shall be submitted to arbitration, right? The third term shall, if the receiver adopts the contract, be enforceable by or against him or so far it's related to any such disputes. Right, so insolvent they generally deal with other related stuff, like they'll be given some time for that person to regain his financial status, and then they pay for it. And generally they will be terminated. The contract will gets lapsed. Contract of that particular insolvent contractor will be lapsed, and then generally they'll be given some time to repay the loss or something like that. And all those things are pretty much important. We'll talk about New York Convention Award. It's our international arbitration or foreign awards. We'll talk about this after our CAT 2. So New York Convention Award, and there's another thing is called Geneva Convention Award. So it's a very big topic by itself. So generally we will skip this for a moment, and we'll come back to this later after your CAT 1. Right. So let me go through the other aspects. Yeah, next will be the final portion of this will be the conciliation. Unlike arbitration, conciliation or the within the organization or among the organization settlement, right? So they don't go for arbitration proceedings. In that, a third party. So you can see that it could be a maximum of a single person or three-person. So yeah, maximum of two or three, and one person conciliator, right? So they generally look into, and conciliators are like not necessarily as equivalent to an arbitration tribunal, but it will be the experts in that field, or if it is like industrial organization leader or something like that. So they can political leader also, so they can amicably settle the matter in front of him or something like that. And this will be just sometimes word of mouth, not necessarily a written document. It will be generally word of mouth. It's just like a counseling or something like that. So that's basically the conciliation. It's just a middle step before arbitration. And all these things, like conciliators are not bound by certain attachments, so which means that they are not bound by civil, they are not legal guys, no, they don't look into Indian evidence act. It's almost conciliations are like counseling, or just like mediating between two parties, something like that. And they also can get administrative assistance, like they can also get help, like I'll ask the expert and get back to you, something like that. They just say it's an oral, most of them will be oral, but sometimes some organization record this proceedings also. And it will be confidentiality, like it is not like one-sided. It should be a person who has trust, who both parties trust, and his verdict was something considered to be more important and final, something like that. And it also incur cost, deposits, and other related stuffs like an arbitration, but it's not very big in case of arbitration. And then finally, the supplementary provisions like the power of high courts and other related stuffs like repeal and savings. And this is repeal and saving is the arbitration conciliation third ordinance 1996, order 27 of 1996, hereby replaced here, right, somewhere.